Welcome to the deep dive. Today, we're really diving into something complex, aren't we? UK child support law.
We certainly are. It's a field that's seen huge changes over the years.
Right. And our mission in this deep dive is to unpack the source material you've got there, these excerpts on child support and the Child Support Acts, to help you, our listeners, understand how it all developed.
Yeah, how it evolved, what the rules look like now under the current system, and maybe crucially where the courts still fit into the picture despite all the big reforms.
Exactly. And we should mention, this deep dive is based on materials made available by the University of London for educational purposes.
That's right. And it's brought to you by Sinorbit Academy, Sri Lanka.
And for all of you studying for exams, we really hope this helps. Good luck. Just remember, this material is for educational use only.
Absolutely. And understanding this stuff, well, it's vital, isn't it? Whether you're a student getting your head around family law for exams, or maybe someone actually going through a family separation.
Or even just curious about how the system that's supposed to support kids actually works in practice.
Precisely. It's an area that's seen so much change, mostly trying to make things more consistent, easier to enforce, and, let's be honest, manage the cost to the state.
Okay, let's get into it then. Let's trace that journey through UK child support history and figure out where things stand today.
Sounds good. So, maybe the best place to start is before the big shakeup, before the Child Support Act 1991. What did the landscape look like then?
Right, before the CSA 91.
Well, back then, dealing with maintenance for children, it was basically all down to the courts.
So judges were making all the calls on child support amounts?
Pretty much, yeah.
Right.
They operated under different laws, different statutes, depending on whether the parents were married, divorcing, or maybe separating without divorce.
Okay, so for married couples getting divorced, what was the main law?
For divorce situations, the main one was the Matrimonial Causes Act, 1973. You'll see it referred to as the MCA, 1973.
MTA 1973. Got it.
And if people weren't divorcing but still needed maintenance, maybe through the magistrates' courts, there was also the Domestic Proceedings and Magistrates' Courts Act 1978, the DPMCA 1978.
Okay, so focusing on the MCA 1973, when a couple divorced, what kinds of orders could the court actually make, specifically for the children?
The courts had quite wide powers under the MCA 1973. They could make what are called periodical payments orders. That's your regular weekly or monthly maintenance.
Standard maintenance payments.
Exactly. They could also make secured periodical payments orders where the payment is sort of guaranteed against an asset like a house.
Ah, okay. To make sure it gets paid.
Right. And they could order lump sums, just one-off payments. And all of these were specifically stated as being for the benefit of a child of the family.
And could the money go straight to the child, or did it usually go to the parent looking after them?
It could be either. The order could say pay the child directly or pay another person, usually the parent, with care for the child's benefit. But what's really interesting, and quite different from the later system, was the court's power under the MCA 1973 to make property adjustment orders.
Property adjustment, so moving assets around.
Yes. This wasn't just about cash for the child's day-to-day needs. It meant the court could actually order, say, the transfer of one spouse's share in the family home over to the other spouse.
Oh, well, okay, but why?
Crucially, it had to be for the benefit of the child. The idea was often about providing a home for the child.
Ah, so making sure the child had stable housing was seen as a direct benefit.
Absolutely. Providing that secure home environment was a key consideration. There's a really important case here, KVK from 1992.
KVK.
Yes, KVK. In that case, the court ordered the father's interest in the family home to be transferred to the mother, specifically so she could carry on providing a home for their children. It really shows how courts used capital assets, not just income, to meet children's needs back then.
That's a significant power. But the notes mention a limit courts usually wouldn't make orders that lasted forever, especially if the child was grown up and didn't have a disability or wasn't studying.
That's a really critical point about the pre-CSA court approach. You've got to grasp this. Their main focus was providing support during childhood, or while the child was still dependent because they were in education or training or maybe had a disability.
So not setting up an adult child for life.
Generally, no. Unless those specific circumstances of continued dependence were there. The source mentions cases like Lifford v. Glynn from 1979 and HVM from 1992. These cases consistently show the courts stopping maintenance around adulthood, unless there was a good reason, like further education or disability.
Okay, so when judges were making these decisions under the MCA 1973, what factors do they have to weigh up? What was the checklist?
Section 25.3 of the MCA 1973 spells it out. The court had to look at specific things. First, the child's own financial needs and
What the
resources.
child needed. Oh,
Any physical or mental disability the child had, and how the child was being educated or trained or how they were expected to be.
right, the child's specific circumstances.
But also, crucially, the court had to look at the parents, their financial resources and needs, both of them, their standard of living before the marriage broke down, and any disability either parent might have. It was a real balancing act, looking at the whole family picture.
It sounds very discretionary,
Yeah.
based on the individual family.
Very much so. It was all about judicial discretion. Now, before we move off the MCA, you mentioned child of the family earlier. That term seems really central. What did it actually mean back then?
Yeah, child of the family.
Absolutely crucial term. Section 52 of the MCA 1973 defined it. It wasn't just about biological or adopted kids of both parents. It also included any child who had been treated by both parents as a child of their family.
Treated by both. So, like, stepchildren could be covered.
Exactly. That was the key thing. This definition brought stepchildren into the court's power for maintenance and property orders if both the biological parent and the step-parent had treated that child as their own within the marriage.
Even if the step-parent didn't know they weren't the biological father at first.
Yes, interestingly, that could still count. There's a case mentioned, WRJ v. WSJ from 1972, which suggests that. It also covered kids who were privately fostered if they were treated as part of the family unit.
But the source says the treatment had to happen after the child was born and within a family context.
Correct. Those were important qualifiers. Treatment had to start post-birth. That was confirmed in AVA in 1974. And it had to be, genuinely within the family setup, not just someone acting as a helper or in a professional role. The case Re M, A minor, highlighted that need for a family context.
Okay, this raises a big question then. If you have a child of the family, but one parent isn't the biological parent, say, a stepdad, how did the court decide if he should pay maintenance? Was it automatic?
Not automatic, no. That's where Section 25 of the MCA 1973 came in. It laid out specific factors the court had to consider for a non-biological parent.
Like what?
They'd look at, did that person actually assume responsibility for the child's maintenance? To what extent did they take on that responsibility, and on what basis, why did they do it, and for how long did they carry that responsibility?
So how involved were they financially?
Yes, and also, did they know the child wasn't biologically theirs when they took on that responsibility? That was a factor.
Knowing the biological facts mattered.
It was considered, yes. And maybe, most importantly, the court also had to look at the liability of any other person to maintain the child.
Meaning the biological father, usually.
Exactly. The court would always weigh up the step-parent's potential liability against the biological, non-resident parent's primary responsibility.
Right, look at everyone who could potentially pay.
Yeah.
There's a case mentioned here, Re-A from 1998. That sounds relevant.
Oh, Ray CA is a fascinating one. Court of Appeal, it really tested the limits of child of the family. It involved grandparents who'd basically stepped in and taken over full-time care of their grandchild because of difficult circumstances.
Grandparents being asked for maintenance.
Potentially, yes. The court found that because their commitment was so deep, they were doing the day-to-day care, making big decisions about health, school. The child called them mom and dad. They had treated her as a child of their family. It went way beyond just normal grandparently affection.
Wow.
So this meant they could, in theory, be liable for maintenance claims against them under the relevant law. In that case, it was actually under the Children Act 1989, but the principle was the same. It showed that treatment had to be really significant, almost like taking on a parental role.
That sets a high bar. So that definition could stretch, but only in quite specific situations. You mentioned age limits earlier. Can we just nail those down for the MCA 1973?
Sure. Section 29 of the MCA 1973 was the key section here. The general rule was no new financial orders, periodical payments, lump sums property, for a child who'd already hit 18. and any existing periodical payments order automatically stopped at 18.
Stop dead at 18.
Generally, yes. But there were really important exceptions in Section 29. The age limits didn't apply if the child was still in education or training, or if there were special circumstances, the main one being a disability.
So support could continue past 18 for students or disabled children.
Exactly. The court could make new orders or continue existing ones for those older children if those conditions were met. Also worth remembering, Section 29(4) said periodical payments stopped automatically if the person ordered to pay died.
Okay. And who could actually apply for these orders under the MCA 1973? Could the child ask themselves?
Under the MCA 1973 itself, no. Only a party to the marriage, the husband or wife, could apply for an order for a child within their divorce or separation case.
So the child had no standing.
It's not directly under the Act. However, there was a procedural loophole. A child, acting through an adult representative, a next friend, could intervene in their parents' existing matrimonial proceedings, even years after the divorce, to ask for financial provision. The case for that is Downing v. Downing, Downing intervening, from 1976.
So they could get involved later on, just not start the case themselves. Okay, that covers orders when a marriage ended. What if the parents were still married, maybe separated but not divorcing? Could courts order child maintenance then?
Yes, they could. Section 27 of the MCA 1973 allowed a party to apply for periodical payments and lump sums for children during the marriage. The criteria the court used were pretty much the same as on divorce Section 25, 3 and 4 factors, and the age limits from Section 29 applied too.
And you mentioned the DPMCA 1978 earlier. That covered similar ground.
Yes, the DPMCA gave similar powers, often used in the magistrates' courts for quicker, perhaps less complex situations. Similar criteria, similar age limits. It was another route to maintenance outside of full high court or county court divorce proceedings.
And there's a recent case mentioned, Siddiqui v. Siddiqui.
Yes, Siddiqui from 2021. It basically confirmed that these powers, both under MCA Section 27 and also under Schedule 1 of the Children Act 1989, which we'll come to, are really meant for sorting out children's financial needs when parents separate. They're not generally intended as a way for adult children to claim ongoing support from parents outside that specific context of relationship breakdown.
Okay, that clarifies the purpose.
Yeah.
Now, you just mentioned Schedule 1 of the Children Act 1989. How did that fit into the picture before the CSA took over everything?
Right. Schedule 1 of the Children Act 1989. This came in just before the main CSA rules kicked in. It created its own separate code for financial support orders, mainly against a child's parent.
And parent under Schedule 1.
Right.
Was that just biological parent?
Yes. No, it was broader, and this is key. It included biological parents, adoptive parents, and also parents defined under the Human Fertilization and Embryology Act 2008 that covers things like surrogacy and donor conception. But crucially, paragraph 16(2) of Schedule 1 also included any party to a marriage, current or former, if the child was a child of the family of that marriage.
So Schedule 1 could also be used to claim against step-parents who had treated the child as their own, just like the MCA.
Yes. Exactly. If the child was a child of the family of the marriage, the step-parent could be pursued for financial orders under Schedule 1. This was different from, say, a biological parent's unmarried partner. They generally wouldn't be caught by the Schedule 1 definition of parent. That distinction came out in Rejay in 1992.
Okay, and what orders could you get under Schedule 1? Was it the same as the MCA?
Pretty similar. Schedule 1 allowed courts to order periodical payments, but, and this is a big but, that power got heavily restricted once the CSA 1991 came fully into force, because the CSA took over the main job of setting periodical payments.
Right, so the CSA trumped Schedule 1 for regular maintenance.
Largely, yes. But Schedule 1 also allowed for lump sum orders and property transfer orders, just like the MCA. And again, these could be paid to the child or to the applicant, usually the parent with care, for the child's benefit. That idea of using capital for housing, like in KVK, was definitely possible under Schedule 1, too.
So property orders for housing were still on the table under Schedule 1.
Yes. Although, after the CSA arrived, courts applying Schedule 1 started saying that lump sums under it should really be for specific capital spending, buying furniture, maybe a car needed for the child, adapting a home for a disability rather than just being a way to pay maintenance up front in a lump sum.
Why the distinction?
Because ongoing maintenance was now seen as the CSA's territory. The court's role with lump sums under Schedule 1 became more about specific one-off capital needs. The case Phillips v. Peace from 1996 made that point quite clearly.
Got it. And the criteria for making Schedule 1 orders, similar to the MCA checklist.
Very similar, yes. Paragraph 4 of Schedule 1 says the court must look at all the circumstances, including the financial resources and needs of the applicant, the parents, and the child, any disability the child has and their education or training needs.
And what about holding step-parents liable under Schedule 1? Same factors as the MCA.
Pretty much identical. Paragraphs 4.1 and 4.2 bring in those same considerations. Did they assume responsibility for maintenance? What was the extent, basis, duration? Did they know they weren't the biological parent? And what about anyone else liable? Same checklist.
Now, here's something really interesting the source highlights about Schedule 1. Unlike other parts of the Children Act, where the child's welfare is paramount,
Ah, yes, the paramountcy principle.
that's not the rule for financial orders under Schedule 1.
That's absolutely right, and it's a classic exam point. For Schedule 1 financial orders, the child's welfare is not the court's paramount consideration. The court must have regard to the child's welfare, sure, it's one of the circumstances of the case, but it doesn't override everything else.
So what does override it then?
The court is balancing all the factors listed in paragraph 4, the finances, the needs of everyone involved. It's a financial balancing act, not solely driven by welfare, unlike decisions about, say, where a child lives. That's a key distinction.
Definitely one to remember.
Mhm.
What other things might a court look at when making a Schedule 1 order?
Well, they try to make sure the award wasn't unfairly influenced by whether the parents happen to be married or not. They might look at the non-resident parent's lifestyle and try to ensure the child benefits somewhat proportionately, especially in high-income cases, though they were wary of just giving the parent with care a windfall. Liability was usually seen as ending around minority. If a step-parent was involved, the court would think about their own biological kids, too. And for disabled adults applying, the court could look at all their needs, maybe broader than the later CSA rules allowed.
And the duration and age limits for Schedule 1 orders, similar to MCA.
Broadly similar, yes. Usually, no new orders over 18, and periodical payments stopped at 18. But Schedule 1 had a specific escape clause in paragraph 2. This allowed a child over 18 to apply themselves directly.
A child could apply.
Yes, if they were over 18 and in education or training or had special circumstances like a disability. But there was a catch. They couldn't use paragraph 2 if their parents were living together at the time. Also, like the MCA, payments stopped if parents got back together for more than 6 months or if the payer died.
And who could actually bring a Schedule 1 application? It sounds broader than the MCA.
It was broader, yes. Applicants could be parents, biological, adoptive, HFEA parents, and step-parents if they fit the definition, guardians, or anyone holding a residence order for the child. And, as we just said, crucially, a child over 18 in those specific circumstances could apply themselves under paragraph 2. Also, courts could make Schedule 1 orders even without a formal application sometimes, like during residence order proceedings or if a child was a ward of court.
Okay, so summing up the pre-1991 world.
Hmm.
It was basically judges making decisions case by case, using different laws like the MCA and Schedule 1, looking at lots of individual factors, and having the power to order regular payments, lump sums, and even property transfers. Very discretionary.
That's a good way to put it. A discretionary court-based system trying to tailor solutions to each family. But it had its problems.
Which leads us neatly into the big change.
Yeah.
The Child Support Act 1991. Why the massive overhaul? What was so wrong with the old system?
Well, there were growing concerns, really boiling down to two main things highlighted in the source material. Firstly, the court system was seen as, well, not working very well.
How so?
It was seen as ineffective, inconsistent awards varied wildly depending on the court or judge and often incredibly slow. Enforcement was a huge issue, too. Just because you had a court order didn't mean you actually got the money.
A postcode lottery and hard to enforce.
Right. Exactly. Secondly, and this was a massive driver, the government was getting seriously worried about the ballooning costs of welfare benefits, especially income support, being paid out to single-parent families.
The taxpayer argument.
Absolutely. There was a strong feeling in government that this cost was high, partly because maintenance from non-resident parents either wasn't being paid or wasn't being pursued properly through the courts, or the amounts ordered were too low.
So the state was picking up the tab that parents should have been covering.
That was the core policy belief driving the change. The idea was that parents who could afford to pay should maintain their children, reducing the burden on the taxpayer. The white paper that came out before the act, called Children Come First, was pretty blunt.
What did it say?
It pointed out that lots of single mothers weren't even seeking maintenance, that court financial settlements often let non-resident parents off lightly on maintenance, and it included the rather sharp criticism that courts seem to have lost sight of the taxpayer's interest.
Ouch. Criticizing judges like that.
It was strong stuff. The case Delaney v. Delaney is sometimes mentioned here, where a court seemed to count the wife's potential welfare benefits as part of her resources, which the government saw as the court basically letting the parent off and putting the cost onto the state
So the government's answer was,
to take it away from the judges, largely. To set up a new administrative body, the Child Support Agency, or CSA, which would have powers to track down non-resident parents, get income details directly from employers and the taxman.
cut out the court process for finding income.
Yes. And crucially, assess maintenance using a standard mathematical formula. The idea was objectivity, consistency, and efficiency.
Get away from judicial discretion and use a calculator instead.
Essentially, yes. The aims listed in that Children Come First paper were pretty clear. Parents should pay, if they can, be fair to parents with multiple families, get consistent results via the formula, allow for reviews, keep work incentives, run an efficient service, and fundamentally cut the welfare bill by getting maintenance flowing.
Makes the policy very clear. And the act itself, the CSA 1991, it focused just on the regular maintenance payments, right? Leaving other stuff like lump sums to the courts.
Correct. The long title of the act makes it clear it's about the assessment, collection, and enforcement of periodical maintenance payable by non-resident parents. That specific task was meant to be stripped from the court's main role.
But we know the story didn't end there. The launch of the CSA in 1993, well, it wasn't exactly smooth sailing, was it?
That's a massive understatement. It faced huge criticism almost immediately. From parents with care who found it just as slow and ineffective at getting money as the courts had been, sometimes worse, and from non-resident parents who felt the formula was incredibly harsh, inflexible, and didn't account for their circumstances, like high travel costs to see kids or debts from the marriage.
So problems on both sides,
Hmm.
leading to more changes.
Yes, several rounds of reform. There was the Child Support Act 1995 trying to tweak things. Then a bigger overhaul with the Child Support Pensions and Social Security Act 2000, the CSPSA 2000.
What did the 2000 Act do?
It brought in a brand new, much simpler formula based on percentages of net income and tougher enforcement powers. But even that doesn't solve all the problems. The agency continued to be plagued by administrative issues, IT failures, and poor performance.
So, more reviews.
Yes. Eventually leading to a major review by Sir David Henshaw in 2006. His report basically said the state shouldn't be involved by default. It should only step in if parents couldn't agree themselves or if one parent was deliberately avoiding payment.
A shift away from state intervention.
Definitely. And that thinking directly led to the next big piece of legislation, the Child Maintenance and Other Payments Act 2008, CMOPA 2008.
CMOPA 2008. And that's the basis of the current system.
Pretty much, yes.
Yeah.
CMOPA 2008 brought in the current formula, based on gross income this time, and crucially, changed the whole philosophy. It actively started encouraging parents to make their own private arrangements, family-based arrangements.
How did it encourage that?
Primarily through access and fees. The Child Maintenance Service, CMS, which replaced the old CSA for new cases from 2012 onwards, was set up under the 2008 Act, while it provides calculation, collection, and enforcement.
There's a catch.
Yes. If you want the CMS to actually collect the money for you, the collect and pay service, you now face fees. The non-resident parent pays a surcharge on top of the maintenance, and the parent with care has a fee deducted from what they receive. There's also often an application fee just to get the CMS involved.
Charging people to use the state system.
Yeah.
That's a big stick to push them towards private agreements.
It absolutely is. The clear policy goal now is state intervention as a last resort, not the first port of call. So while the 1991 Act is still the bedrock law, it's been heavily amended, and the system operates mainly under the 2008 Act rules and the CMS structure. The old CSA still handles some legacy cases, but new applications go to the CMS.
Okay, so let's dive into the nuts and bolts of this current system, operating under the CSA 1991 as amended by CMOPA 2008. Section 3 in the notes talks about key concepts and that formula.
Right. The absolute starting point is the legal duty to maintain. Section 1.1 of the CSA 1991 lays it down. Each parent of a qualifying child is responsible for maintaining them.
Each parent.
And Section 1.2 clarifies that for the parent who doesn't live with the child, the non-resident parent, they meet this duty by making the periodical payments calculated under the Act's rules, basically by paying the formula amount.
Okay, so it all hinges on being a qualifying child and having a non-resident parent and a person with care. These definitions must be absolutely vital.
They are the gatekeepers to the whole system. If you don't meet these definitions, the CMS generally isn't involved. They're all defined in Section 3 of the CSA 1991. A child is a qualifying child if one or both parents is a non-resident parent for them.
Simple enough. But how is child defined here? Is it just anyone under 18?
Not quite. Section 55(1) defines child. It's someone under 16 or someone aged 16, 17, 18, or 19 who is in approved full-time non-advanced education, so school or college, generally not university, or meets other specific conditions.
Non-advanced education. That's a key limiter.
It is. And there's another crucial exclusion. Someone who is married or has been married cannot be a child for CSA purposes, regardless of their age or education status.
Once married, you're out, even if you're 17 and still at school.
Correct. That's a hard stop under the CSA rules. Now, non-resident parent,
The one who doesn't live with the child.
defined in Section 3(2). It's a parent who doesn't live in the same household as the child, and the child lives with a person with care.
And parent here means the legal parent, biological, adoptive.
Yes. Section 54 definition, it's the legal mother or father, natural, adoptive, or defined as a parent under the HFEA 2008 for assisted reproduction cases. It's about legal parentage, not necessarily biological ties in isolation.
Okay, so non-resident parent, legal parent not living with the child, plus child lives with the person with care. What about the person with care?
Defined in Section 3, it's the person the child lives with who usually provides the day-to-day care, can be jointly with others, and isn't in an excluded category.
Who can't be excluded.
Section 3(4) says parents, guardians, and people with residence orders, now child arrangements orders specifying residence, cannot be excluded by regulations. The main excluded groups set by regulations are local authorities and local authority foster parents.
So if a child's in care, the CSA system doesn't apply to the council or foster parents.
Correct. The liability still rests with the parents, but the mechanism isn't the standard CMS application by the local authority as a person with care.
Right. So let's recap the entry requirements for the CSA CMS system. You need legal parents, one or both, not living with the child living with a person with care, not the council foster carer, the child fitting the age, education, marital status definition, and generally everyone living in the UK.
That's a perfect summary of the gateway criteria. If all those boxes are ticked, the CMS likely has jurisdiction.
Now, welfare. We talked about how under Schedule 1, welfare wasn't paramount. What about under the Child Support Acts? Does the child's welfare influence the calculation?
Good question, and another key point. Section 2 of the CSA 1991 deals with welfare. It says that when the Secretary of State or a child support officer uses a discretionary power under the Acts, they have to consider the welfare of any child likely to be affected.
Only for discretionary powers,
Yeah.
not the main calculation.
Exactly. This is vital. Calculating the maintenance using the formula is not seen as a discretionary act. It's applying a statutory calculation. Therefore, the Section 2 duty to consider welfare does not apply to the basic formula calculation itself.
So the formula amount is fixed regardless of the child's specific welfare needs.
Pretty much. Welfare might become relevant if the officer is deciding something like whether to accept a variation application based on special expenses or how to enforce arrears areas where they have some choice, but the core amount, that's dictated by the formula inputs, income and number of children.
Right, let's get into that formula. This is the heart of the CMOPA 2008 system, taking discretion away. How does it actually work?
It's based primarily on the non-resident parent's gross weekly income, that's income before tax and national insurance, and the number of qualifying children they need to pay for.
Okay, walk us through the rates.
Sure. There are different percentage rates applied depending on income bands. First, for gross weekly income up to £800, the basic rate applies. For one child, it's 12% of that income. For two children, 16%. For three or more, 19%.
Okay, 12, 16, 19%, up to £800 gross.
Right. Then, if the income is over £800 a week, up to a ceiling of £3,000 a week, an additional rate kicks in on the income above £800.
So a lower percentage on the higher chunk of income.
Yes. For one child, it's 9% on the income between £800 and £3,000. For two children, 12%. For three or more, 15%. So the total calculation is the basic rate amount plus the additional rate amount.
What about parents earning very little, say under £100 a week?
If the gross weekly income is under £100 or they're on certain benefits, there's usually a minimum flat rate payment, currently £7 per week. There's also a reduced rate calculation for incomes between £100 and £200 a week.
So some minimum payment, even on very low incomes. Yeah. Is there a maximum the formula can churn out? A cap?
Yes, there's an effective cap. The percentages are only applied up to a gross weekly income of £3,000. So even if someone earns vastly more than that, the formula calculation itself doesn't go any higher. The absolute maximum maintenance calculated under the formula for someone on £3,000 plus gross per week with 3 plus children is currently $482 per week.
$482 a week max from the formula. But what if the non-resident parent is a millionaire? Can the parent with care get more than that?
Yes, they can, and this is where the courts come back in. This is the top-up jurisdiction we mentioned. If the CMS formula produces that maximum assessment, 482 week, the person with care can apply to the court under Schedule 1 of the Children Act 1989.
To ask for more money on top.
Exactly. Under Section 8.6 of the CSA 1991, the court has the power to order additional periodical payments on top of the maximum CMS amount if they think it's appropriate, given the non-resident parent's very high income or wealth. It's a key residual power for high-income cases.
Okay. Now, income for the formula, is it just salary? What about other things? The source mentions some cases here.
Good point. The primary basis is gross taxable income, often taken from HMRC records. But defining what counts can get tricky. The French case dealt with a professional gambler's winnings should they count. The EB case looked at a redundancy payment. These cases showed that applying the gross income rule to unusual financial situations isn't always straightforward and sometimes needs tribunal or court decisions to clarify what counts as income or resources for the calculation.
So it's not always just the P60 figure. What about shared care? Does the formula adjust if the kids spend a lot of time with the non-resident parent?
Yes, it does. This is a really significant feature introduced to reflect and arguably encourage shared parenting. The calculated maintenance amount is reduced if the child stays overnight with the non-resident parent regularly.
How much is the reduction?
It's tiered. If the child stays overnight for 52 to 103 nights a year, that's average 1 to 2 nights a week, the maintenance is reduced by 17th. For 104, 155 nights, average 2-3 nights, it's reduced by 27ths. For 156, 174 nights, it's 37ths. And if it's 175 nights or more, basically equal shared care, the reduction is 1/2.
So significant discounts for substantial overnight care. How does a parent actually start the process with the CMS?
The first step nowadays is usually through a service called Child Maintenance Options. It offers information and advice, can do an online calculation estimate, and supports parents in making private arrangements.
The family-based arrangements route first.
Exactly. If that doesn't work, or if one parent wants the formal system, Child Maintenance Options can refer them to the Child Maintenance Service, CMS, to make a formal application.
Who can apply to the CMS?
Usually the parent with the main day-to-day care, the person with care, or the parent without the main day-to-day care, the non-resident parent. In some situations, a grandparent or guardian caring for the child could also apply.
And what does the CMS do once they get an application?
They formally calculate the maintenance amount using the formula. Then they offer 2 main service types. Direct pay is where CMS tells parents the amount, but the parents sort out the payments between themselves.
No fees for direct pay.
Generally, no ongoing fees for direct pay, though there might be the initial application fee. The alternative is collect and pay.
Where CMS collects the money and passes it on.
Right. CMS collects it from the non-resident parent. They have enforcement powers if needed, and pays it to the person with care. But this is the service where those fees kick in.
The 20% surcharge for the payer and 4% deduction for the recipient, roughly.
Those are the current rates, yes. A significant financial incentive built into the system by CMRPA 2008 to avoid using collect and pay, if possible, and stick to direct pay or a fully private agreement.
That really hammers home the policy shift towards private agreements.
It absolutely does. The whole system now is geared towards encouraging parents to sort it out themselves first, with CMS as the backstop, but a backstop that comes with a cost if you need the full collection service.
And the scale is huge. You mentioned stats earlier. Hundreds of thousands of children covered.
Yes, the CMS manages arrangements for a vast number of families. The statistics highlighted in the source, like covering over 737,000 children between 2015 and 2020, just show the sheer volume and impact of this administrative system.
Okay, we've got the current system structure. Now, Section 4 in the notes is absolutely critical, the residual jurisdiction of the courts. When do judges still get involved?
Yes, this is so important for understanding the boundaries. The starting point, the main rule, is Section 8.3 of the CSA 1991. It says basically, if the CMS can make an assessment for periodic maintenance, the court cannot make, vary, or revive its own maintenance order for that child against that parent.
Section 8.3. CMS jurisdiction excludes court jurisdiction for standard maintenance. The exclusion principle.
Precisely. Where the CMS applies, it takes precedence for regular child support, but the Act itself then creates specific exceptions, areas where the courts keep their powers.
Right. Let's list these exceptions carefully. What's the first one?
First, the courts keep their powers entirely if the CMS has no jurisdiction in the first place. This happens if the child isn't a qualifying child under the Act's definition.
Like when? Give us examples.
Okay, so maybe the child is over the age limit and not in qualifying education. Or the child is married. Or maybe the case involves a step-parent where the strict CSA rules on liability aren't met. Or perhaps one of the parents lives abroad, outside UK jurisdiction for the CMS. In those scenarios, because the CMS can't act, the court's powers under, say, Schedule 1 of the Children Act, 1989, remain available for maintenance.
So if the CSA-CMS rules don't fit the situation, the old court powers under Schedule 1 or MCA might still apply.
Exactly. The court fills the gap where the administrative system doesn't reach.
Okay, exception 1. No CMS jurisdiction was number 2.
Number 2 is the top-up power under Section 8.6, which we've touched on, where the CMS has made an assessment, but it's the maximum possible amount under the formula, £3,000 plus income. The court can step in and order additional periodical payments on top of the CMS figure.
So court adds more for the very high earners. Got it. What's next?
Third, and this is a big one, lump sums and property adjustment orders. The CMS only deals with periodical payments, regular maintenance. It has no power to order one-off capital sums or transfer property.
So courts keep all their powers for capital.
Yes, full jurisdiction remains with the courts under the MCA 1973 and Schedule 1 of the CA 1989 to deal with capital provision for children, lump sums for specific needs, transferring property for housing, like in KVK. The CMS doesn't touch capital.
That's a major area left to the courts. Okay, fourth exception.
Fourth is maintenance specifically for education or training expenses under Section 8.7. Even if the child is, say, 17 and CMS might have jurisdiction for basic maintenance, the court can make an order solely for costs related to their education or training, things like school fees, specific course costs, books, etc.
So specific educational cost orders are still possible via court. And
Fifth relates to disability expenses under Section 8 and 9. Similar idea. The court can make an order solely to cover expenses arising because of a child's disability. This applies whether the child gets a disability benefit or not, as long as they are disabled. Again, the order must be only for those extra disability-related costs.
Okay. And the final area of court power.
The sixth main one is orders against the person with care. The CMS system is designed for the non-resident parent to pay the person with care. It doesn't generally allow for orders the other way around, but the court retains power to order a parent with care to pay maintenance, for instance, if an adult child applies under Schedule 1, Paragraph 2 against both parents, including the one they live with.
Right, so the court can make the resident parent pay in certain situations, like an adult child's claim. Okay, let's quickly list those 6 residual court powers again, just to be crystal clear for everyone listening. 1. CMS has no jurisdiction, child doesn't qualify, residency issues, etc. 2. Top-up orders when CMS hits the maximum calculation. 3. All lump sum and property adjustment orders, capital provision. 4. Orders solely for education training expenses, over 16.87. 5. Orders solely for disability-related expenses, 6.8110. 6. Orders against the person with care.
That's the definitive list. It shows that despite the administrative takeover of standard maintenance, the courts still play a vital role in specific, often more complex financial aspects of child support.
Let's use that example from the source, Activity 7.3. Mary and John divorced in 2013. Son James is 10. Where does Mary go for maintenance?
Okay, apply the rules. James is 10 under 16, so he's a potential qualifying child. They're divorced. James lives with Mary, assume she's a person with care. John is non-resident parent. Divorce was 2013, well into the CMS era under CMOPO 2008 rules, assuming they're in the UK.
Then James is a qualifying child, and CMS has jurisdiction for standard maintenance.
Precisely. Section 8.3 kicks in. The court cannot make a standard periodical payment order. Mary must go through the CMS route, starting with child maintenance options, likely leading to a CMS calculation.
And the court only gets involved for those residual things, lump sum, property, top-up if John's a high earner, specific education or disability costs if they arise later.
You've got it. The core maintenance calculation belongs to CMS. The court handles the exceptions.
That example really clarifies the boundary line.
It does. It shows how the system is supposed to work in a standard case.
Right. Let's shift to Section 5, Child Support in Action. looking at cases and the real-world problems, especially enforcement.
Yeah, the early years after 1991 and even later saw lots of cases as everyone tried to figure out how this new CSA system worked alongside the old court powers.
What did those early cases show us?
Well, AVA, a minor financial provision, from 1994 involving unmarried parents using Schedule 1, showed courts could still use their capital powers, like settling property for housing, though not outright giving it away. It also suggested court orders could include an element for the carer's needs, and it restated that principle about provision usually ending around adulthood.
Focus on needs during dependency, like housing. Makes
Yeah.
sense.
Then there was Mawson v. Mawson, also 1994. This was a divorce case with the CSA assessment running alongside. It really highlighted the interaction. The CSA assessment changed due to law changes, not income changes, and the court had to adjust the spousal maintenance it had ordered to reflect the new child maintenance reality.
Ah, so changes in the fixed child support figure directly impacted what the court did for the spouse.
Yes, the judge basically said changes in the CSA amount, even legislative ones, were foreseeable, and court orders might need adjusting to cope. This really bumps up against the idea of a clean break in divorce.
How so? The clean break principle.
Well, a clean break aims to cut all financial ties between the ex-spouses. But if there's ongoing child maintenance via CMS, that financial link concerning the child continues, sometimes for many years. It prevents a totally clean break. Mawson shows the court trying to juggle achieving a spousal clean break with the reality of the ongoing externally determined child maintenance figure.
What about the TVS case?
TBS, another 1994 Schedule 1 case about property for unmarried parents' kids. It confirms settling property for housing until kids finish education was okay. But it rejected the idea that the property should then go to the kids. It should revert to the paying parent. Again, reinforcing the idea of meeting needs during dependency, not providing long-term capital unless truly exceptional reasons.
And RE-A, child of the family from 1998, we mentioned it for the definition.
Yes, the grandparents case. Crucial for understanding how far child of the family could stretch under the old law, and for Schedule 1 purposes, if the step-parent was married to the parent. It showed that taking on a full-on parental role, deep commitment, could bring someone within that definition, beyond just normal affection. High threshold, but possible.
So the courts were clarifying definitions and interactions, but the administrative system itself, the CSA, it was having massive problems, wasn't it? Especially getting money paid.
Oh, absolutely. The history of the CSA is littered with criticism about terrible delays, delays in making assessments, delays in collecting money, and huge delays and failures in enforcement. It caused real hardship for countless families.
Did anyone challenge this legally? On human rights grounds, maybe?
Yes, significantly. The case R, Kehoe v. Secretary of State for Works and Pensions, went all the way to the House of Lords in 2005. A mother argued the CSA's delays and the fact only it could pursue arrears violated her right to a fair trial and access to court under Article 6 of the ECHR.
And did she win?
Ultimately, no. The law lords found the system wasn't technically incompatible with Article 6, but the case was a huge embarrassment for the government and the CSA. It shone a massive spotlight on just how badly the agency was performing. It was followed by other CSA cases reaching the highest court too, all highlighting problems.
Was there also a negligence claim against the CSA?
Yes, in R. Rowley v. Secretary of State for Work and Pensions in 2007, a mother sued the CSA, claiming their negligent failures in assessment, collection, and enforcement caused her financial loss.
And was that successful?
No, that claim also failed on appeal. But again, like Kehoe, these high-profile legal challenges, even when unsuccessful on the specific legal points, along with relentless bad press, just kept emphasizing the massive gap between the aims of the legislation and the reality on the ground. The system just wasn't delivering effectively for many people.
It sounds like a system constantly trying to fix itself because of these deep-rooted problems, especially around enforcement.
That's a fair description. The ongoing reforms, including CMOPA, 2008 creating the CMS, and the focus on fees and private agreements were all heavily influenced by these past failures. The goal is always to improve enforcement, but history shows it's incredibly difficult to get right consistently for everyone.
Let's just loop back quickly to divorce settlements. How does the fact that CMS fixes a child maintenance figure really change how courts approach the rest of the money?
Fundamentally, because Section 8.3 blocks the court from setting the main child maintenance figure, that CMS calculation becomes a fixed point in the financial landscape. The judge dealing with the divorce has to arrange everything else, spousal maintenance, how capital, like the house, pensions, savings, is divided around that CMS figure. They can't alter the CMS amount itself unless it's a top-up case.
So the CMS figure is like a non-negotiable input into the court's calculations for everything else.
Exactly. It significantly restricts the court's overall flexibility compared to the old days when they decided everything. The court has to work around it, which, as we said, impacts things like spousal support levels and the ability to achieve a truly clean break.
Okay, I think that brings us towards the end of this really detailed deep dive.
It's been quite a journey, hasn't it? We started way back before 1991, with the courts in charge, using discretion under laws like the MCA 1973 and Schedule 1, deciding on periodical payments, lump sums, property orders, and using that key concept of the child of the family.
Then we saw the huge shift with the Child Support Act 1991, driven by aims of consistency, fairness, efficiency, and cutting welfare costs. We followed its bumpy ride through reforms in 1995, 2000, and crucially the 2008 CMPA, which brought in the current CMS, the gross income formula, and that big policy push towards private arrangements, using fees as leverage.
We unpack those core definitions: qualifying child, non-resident parent, person with care, that control who's in the system. We looked at how the formula works, the shared care reductions, and the limited role of child welfare in the calculation, and the court's power to top up in high-income cases.
And maybe most importantly for navigating the system, we carefully identified those 6 specific areas where the courts keep their jurisdiction, where CMS doesn't apply: top-ups, capital orders, lump sums property, education costs, disability costs, and orders against the person with care.
And we saw how case law has shaped understanding, from defining terms like child of the family in RIE to dealing with the interaction between CMS and court orders in Mawson, plus the difficult history of enforcement problems highlighted in cases like Kehoe and Rowley, even if the legal challenges themselves didn't succeed.
So, connecting this back to you, our listener, hopefully this deep dive helps you understand the state's approach to parental financial responsibility, that constant balancing act between a standardized administrative system and individual family realities. You can see where the court safety nets still exist and why this area keeps evolving.
Absolutely. Which leads us to a final thought, maybe something for you to ponder. Running through all these reforms from 1991 to today, there's this underlying tension, isn't there? Between the desire for a clear, predictable, efficient administrative formula and the sheer variety and messiness of individual families' finances and circumstances after separation. Can a formula, however well designed, truly be fair in every single case? Or do we always need some element of judicial discretion, some safety valve like the residual court powers, to handle the complexities and ensure genuine fairness for both parents and, most importantly, the children involved, especially when significant assets or unusual situations arise?
That's a really big question. Efficiency versus individual justice.
It's the core dilemma, and one that policymakers continue to grapple with.
A challenging thought to end on. Thanks for joining us for this deep dive into UK child support law. And once again, good luck to everyone facing exams on this topic.
Thank you. Good luck.